Hi, my name is Robert Wooten, and I'm one of the lawyers here at Curry, Pearson and Wooten. I'd like to talk to you today about mitigation. Mitigation as it pertains to criminal cases. I often find in the practice of criminal law that lawyers take clients and they talk to those clients about a plea agreement, and if the plea is not a favorable plea, we'll just set the matter for trial. In my experience, I found that to be a very short-sighted way to practice criminal law. I've had great success over the years with mitigating cases and mitigation strategies. What do I mean by mitigation? Mitigation is an area where I familiarize myself with my clients. I bring my clients in early after taking a case, and I am known to spend hours with them. I want to know where they went to church. I want to know what their belief systems are. I want to know who they're married to. I want to know who their parents are, what state they were raised in. I want to know as much personal information about them as I can possibly obtain. And you might wonder, why would that be so important? Well, it's fairly simple. I have found out over the years that it's so much easier for me to sit down and talk to a prosecutor about a client that I know intimately versus talking to a prosecutor about someone that I just met in my office who retained me and who's looking for a deal. I typically go to prosecutors' offices before COVID-19, and I simply ask for a meeting. In those meetings, I introduce myself, and if I don't have a packet with me, I'll start by introducing my client, not as the defendant, but as Mr. or Mrs. Joe Smith. I will talk to the prosecutor about the things that I just briefly discussed: my client's work history, my client's family. I typically, and I'm known to have pictures of my client's children, where they go to church, how long my client has worked on a particular job, whether or not they travel, whether or not they have investments, things of that nature. And the prosecutors are somewhat surprised that I know so much about my clients. And I typically or usually will follow that meeting up with a packet that has my client's life in pictures, almost as an exhibit. I have found that when I do that, I can familiarize myself and familiarize the prosecutor and the judge with the person who is going through some sort of a criminal case, but who is yet and still a human being. You would be surprised if I shared with you the numerous instances where my clients got deals that were greatly favorable, especially in co-defendant cases, when no one else could get the deal or the resolution, including dismissals, that I've been able to get. And I credit much of that to my work in the mitigation area or arena. You can always take a case and ask for a plea agreement. And if the plea agreement is not favorable, set the case for trial. But when you do that without mitigation, it is my experience that the client comes out on the short end of the stick. So I highly encourage you to ask any lawyer that you may be interested in hiring what their mitigation practices are. And if they can't give you a favorable answer, I'd love to talk to you about your case or talk to you further about this practice that I believe greatly in, and that is mitigation and mitigation strategies. I hope you have a great day.